Joining us this morning to weigh in on that Supreme Court decision, we have Professor Paolo Tamase from the UP College of Law, all the way from Brazil. Maraming salamat for being with us here.
Hi, good morning, Gretchen, and to your listeners.
Okay, Prof, we do know that Senior Associate Marvic Leonen is the ponente of that SC decision, and he says in the press release, on top of it, our fundamental law is clear. The end does not justify the means. There is a right way to do the right thing at the right time. And this is what the rule of just law means. Mabibigat ang kanyang mga salita doon. Una-una, did you expect that decision, and do you agree with it?
Well, I think in terms of whether we expected the decision, the way that the Supreme Court decides these cases is often a black box. So really, we don't know. We can't expect often how the court will decide the case. I know that some commentators have pointed out to the fact that 13, I think, of the 15 are appointees of former President Duterte. I don't think it matters as much in the final analysis. What I think was surprising was the timing. And it's because these petitions were filed in February. And for the most part, except for the last 2 or 3 weeks, the Supreme Court wasn't really acting on the petition. And then suddenly, just before the SONA starts and the dates that the Senate has already committed to start trial, you have the Supreme Court issuing this decision. And just to appreciate how record-breaking for this particular court the speed is, this is the same court, for example, that took years to decide the province of Sulu case regarding the inclusion of Sulu in the ARMM. Several important petitions pending before the court had yet to be decided. And so this one, considering its importance, without any oral argument or without extensive argumentation, I'm a bit surprised. And I think some academics are a bit surprised with the timing, especially just as a last point, Gretchen, the court meets en banc on Tuesdays. And the decision seems to have been decided in a special en banc session on Friday for the release of the Sharia bar results. So the timing is a little unusual in my view.
So dapat na-release na ito nung end of day, Tuesday pa lang, or Wednesday?
Well, not so much that, no, but we did expect that it wouldn't rule yet last week. Because of the way that the court had to cancel work because of the typhoons in Manila, we thought that it would take more time to deliberate this. In fact, some expected that the court might call for oral arguments, especially because of the number of factual issues that are involved. So we're not surprised that it took long. We're surprised that it took this short, considering the other cases that are also pending before the Supreme Court.
What would have been the big difference here? Kung sakaling nilabas siya during the 20th Congress hearings, na kumbaga parang napag-usapan pa, nabulat-lat pa sana yung issues of constitutionality, wouldn't it have been the same anyway? Since ultimately the Supreme Court is the final arbiter on that.
That's a fair question, right? And it's possible that the court itself would not have changed its mind about the things that it decided, but it may have, affected the way that it decided the matter. So when we talk about Supreme Court decisions, it's not the only thing that's important is the dispositive portion or the last part, whether something is unconstitutional or not. The reasoning often is important, and you have here a 97-page decision that really covers perhaps the entire gamut of impeachment. Even in my academic view, things that were not really before the court yet, or things that were not raised by the parties before the court. And so if you consider how impeachment cases before the Supreme Court were decided, if you look at the Corona impeachment, for instance, when the Senate has already started trial, the court is a little more careful in stepping in because it acknowledges that the evidence has already come out. The parties are already being heard. The Senate is already exercising its power under the Constitution, the sole power to try and decide cases of impeachment, and therefore it adopts what we would call prudence. It will avoid making broad categorical rulings on things that are already before the Senate, and it might even delay its opinion to allow the Senate some time to decide. So that would have affected the fact that the Senate would have started trial, I think would have affected the way that the court would decide the case.
Well, it would have put public pressure on the Supreme Court if you're right, if the evidence is laid before the impeachment court already. Actually, kami rin sa media nagulat na Friday nirelease ito, medyo late na ng araw. Usually, pag weekend, I mean, the news is not as aggressive on weekends as we would want them to be. And it is before the SONA of the president. So parang ano na, no? I mean, I'm sure the senators could breathe a sigh of relief that they don't have to get into a vote at the very start of the 20th Congress. But let's go to the reasoning. As you mentioned, mahalaga yun. And one sticking point here that seems to be, the pivotal change maker is the clarification on the definition of when an impeachment complaint is deemed initiated. So sabi ni former Supreme Court Justice Adolf Ascuna that in the Davide case, the Supreme Court defined initiating an impeachment complaint as putting it in the order of business and referring it to the proper committee, of which what was absent in the first three complaints, hindi siya na-refer. Kaya the House was operating under that jurisprudence na ganun pa rin. How do things change here? I mean, is that, first of all, allowed, the changing of rules midstream, that now when it is not referred to a committee, it is treated as effectively dismissed?
So let's start with the question of whether that's allowed. Justice Ascuna is absolutely correct that this principle was established already in Francisco versus House of Representatives 2003 case. There is another case, Gutierrez versus Committee on Justice, I think a 2011 case, which says the same thing, right? Initiation is when a complaint is filed before the House and it is referred to the Committee on Justice. And the reason why that was the rule in those cases is that the House should have some prerogative to allow a strong complaint to emerge instead of a frivolous complaint. So, ipunin niya muna kung ano yung mga importante na, or kung ano yung mga complaint na nahain, tapos doon niya sabay-sabay na ipapasa sa Committee on Justice. That was the rule. Our Supreme Court is bound by what we call na stare decisis. This rule that like cases should be decided in the same way, even if the parties before it are different. And that means that, that there's a premium that is placed on consistency on the part of the court. We like law to be consistent and we like decisions of the Supreme Court to be consistent because, as Justice Ascuna has indicated, political actors follow what the Supreme Court says and operate under the current rules that they say. So, however, in a hypothetical scenario, the Supreme Court is allowed to change its mind and say that we got a previous ruling wrong or we need to refine it. But typically, if it will cause an inequitable situation, an unfair situation to the parties who relied on the old ruling, the Supreme Court adopts what we call an operative fact doctrine. So sorry for all of these terms. But basically, that means that the court will not apply the new rule to the current case, and it will apply it for future cases. I think that is what Justice Ascuna was saying, and I absolutely agree with his view that when considering that the House was following the old rules in Francisco and Gutierrez, if the court really wanted to change its mind now or refine the rules, however, whichever way you want to look into this ruling, then it might be fairer to the House who relied on the old ruling to be bound by the old rules or how we used to understand them.
So, operative fact doctrine, kumbaga parang na-establish na natin yung facts noon. And if we operated under those facts, that should hold.
Well, it means that, when the court changes its mind, it doesn't mean that na-erase bigla yung consequences of what has already happened before. So to acknowledge the fact that parties acted under a different understanding of law because of what the Supreme Court has said before, as a matter of fairness, the court would not apply the rule to the present case and just apply it in the future. So put that into an example now, the House relied on Francisco and Gutierrez versus House. In that case, the House considered the quote-unquote fourth complaint, no? As not being barred because hindi pa naman nire-refer yung tatlong complaint to the Committee on Justice. And then suddenly you have new rules now in this Duterte versus House decision. If we apply the operative fact doctrine, as Justice Oscuna advocates, then it would be fairer to the House for it to be tested on constitutionality based on what it has done in reliance to the old decision or to the old rule.
Given the tighter definition of initiating an impeachment now, critics worry that dummy impeachment complaints could be filed in the future in order to immunize a sitting official. What are your thoughts on that? I mean, does this open the door to that?
I think in operation it does. No? The key thing that this new decision does is to create two sets of rules. So you have one set of rule that applies to impeachments initiated by filing complaints with the House. No? So there's a citizen who files it, or there's a congressman who files it. And another set of rules, so the court would distinguish it with the impeachments that are initiated by a direct vote of one-third of the House of Representatives. So if you read the decision itself, hindi very clear yung point na yun. But the court makes a very emphatic distinction between the two. So if I were a person who wanted to, let's say, kaalyado ko yung isang impeachable officer, what I would do now is simply to initiate a case, now file it with the House, and therefore preclude the second mode of initiating impeachment complaints, which is by the one-third vote of the House of Representatives, the one that was done now in the case of Vice President Duterte. Ipepreclude ko na yun, no? Maghahain
Baka
ako ng
hindi pa
frivolous
handa
na
at
complaint kasi
wala
in
pang
that
boto.
sense pala, may filing meron nang nahain na old complaint.
Correct. Okay. Bilang panghuli, no, going to the statement of Soljan Florin Hilbay, he said that he argues that the impeachment is designed to be free from judicial interference, that the text, history, and structure of the Constitution's impeachment clauses assign no role for the Supreme Court as an institution. Do you agree with that? At kung ganun, ba't pa tayo nagpunta doon?
So, I understand Soljan Hilbay, who was my constitutional law professor, and his view on this. The Philippine version seems to suggest that the Supreme Court does have a role somehow when it comes to cases of impeachment when there is grave abuse of discretion. And that's something that's in the text of Article 8, Section 1. But I actually agree more with Solicitor General Hilbay that the role of the Supreme Court is very limited. No? And it's really only in very clear cases of grave abuse of discretion and not in cases where there is a plausible excuse on the part of the House. And the reason why that is we go back to American origins of impeachment. In the US, when they were crafting the Constitution, they were trying to decide who would be better to decide impeachment cases. So there was a debate between whether it should be the courts or it should be the Senate. And the Senate won, partly because the impeachment is the only check on the courts, and in our case, the Supreme Court. So if you have the Supreme Court intervening in impeachments, then you open the door to them intervening when they are on trial or when they are being impeached. And that's not really good for our systems of checks and balances.
Okay. Does that mean that the Senate can buckle on this and say that we're not going to follow? Is that possible? Because they have done that in the past. Senate President Jesus Escudero himself has mentioned that kung magro-rule itong Supreme Court, pwede nilang pagdesisyonan na sundin at pwede din hindi.
We looked at the Corona impeachment. No? And the Corona impeachment, in that case, there was a temporary restraining order issued by the Supreme Court against the disclosure of foreign currency accounts of Chief Justice Corona. In that case, the Senate eventually decided to follow the TRO. But what's important there is the Senate decided to vote on it. So they understood and asserted that when it comes to impeachment cases, like start yung trial, sila yung Supreme. So I would understand why the Senate would follow that. But I also understand concerns that, this might trigger some constitutional crisis because we're used to a situation where the
Correct, correct.
Supreme Court is the last word on questions of constitutionality. And siguro, Gretchen, as a final note, this is precisely why courts are invited to exercise prudence when it comes to impeachment. Whenever a political branch that is supreme in its field, so in the cases of impeachment, supreme yung Senate, whenever that branch is questioned by the Supreme Court, there's always that risk that that branch will not follow. And therefore, when that branch doesn't follow, it harms the long-term legitimacy of the Supreme Court. That apparently hindi pala sa kailangan sundin itong branches na to. So I think what's needed from all sides now and from all our public officers is a little more prudence. To be very mindful of their specific roles in this entire impeachment constitutional process and to act according to accountability. What is the best way to interpret our constitution that will further that concept?
Therefore, we go back to your original point about timing, and this was handed out before the 20th Congress even begins today, even before the senators could put it to a vote. So I guess it's either very questionable or very smart. Okay, maraming salamat sa iyo, Professor Paolo, for joining us and for giving us clarity on the issues that surround the Supreme Court's decision on the constitutionality of the impeachment. Thank you again for joining us from Brazil, and mag-ingat ka.